Hey, welcome back. I'm Zachary Harris. I am a lawyer in Winston-Salem, North Carolina. Today, we're going back to one of my favorite pastimes, which is taking a look at some of the questions presented on Reddit's r/legaladvice. If y'all don't know Reddit, it's a little corner of the internet where non-lawyers come ask other non-lawyers for legal advice. It's always interesting to see what they get right and what they get wrong. These questions come from all over the country and all over the world, but I'm only licensed in North Carolina. I'm going to be giving all my answers as though these people were sitting in my office in North Carolina telling me their story for the first time. Let's get into it. Salesman said $2,450, not $2,450. All right. Last Friday, 3 full business days have passed. I had a free termite inspection from the pest control company that I use and generally don't have an issue with. He showed me obvious signs of termites in the backwoods and recommended bait/traps in the backyard. He told me it is only $2,450 annually. I assumed he meant $24.50 and thought, wow, why would I say no to that? It must be low because I already paid for their service. So I signed and they used my card on file. I never even physically saw the dollar amount. Checked my credit card today and I had a $2,450 charge. I then checked my email and read the contract, clearly saying $2,450. I am 10 hours past the cooling off period to cancel. Anything I can do? I feel like I got scammed, even though I know I'm just stupid. I wish I could say that this was uncommon, but it's not. The advent of the iPads have been a disaster for contract formation because people now, more than ever, read contracts without signing them. I do this all the time, so I'm not exempt. Contract on iPad, you just go, I'm not reading all that. You scroll and you sign with your finger at the bottom. We've had these types of contracts for a while. They're called contracts of adhesion. They're called that because they're sort of take it or leave it. The classic is the terms of service agreement when you sign up for some sort of new software. The cookies policy that you never read, but you click accept. Courts are going to enforce contracts. If they're valid on their face, they're going to enforce them. So it's probably correct that this poster is out of luck. There is some daylight. The two aspects of daylight are going to be the fact that it was signed on an iPad and that it's a contract of adhesion. I put those two together. And the salesman's representations of the cost, $2,450. Odds are good that the poster's not getting out of this contract, unless the termite company lets them out, which they may do. Let's keep in mind here that your legal rights and the recoveries under the law aren't determinative of what people might be willing to do. There's a lot of other considerations, right? You're a long-term customer. We want to keep your business. We know that if we make you pay $2,450, you are never calling us ever again. And you're going to tell everyone you know to never call us ever again. It's better for us to say, oh, we're so sorry for that confusion. As a courtesy, we will let you out of the contract. Or as a courtesy, we'll charge you the $2,450. I wouldn't discount that. And I'll say, by the way, getting a lawyer involved to ask for that probably doesn't help. In my experience, when I send a letter, everyone sort of buckles down and gets ready for lawsuit. It's not often that getting a lawyer involved brings people to the table. It usually makes people sort of go to their corners and get ready for a lawsuit. I would encourage the posters to send an email to the manager of the company, the owner of the company. Be firm, but don't be accusatory. I mean, say, look, I didn't understand what this was. The salesman said $2,450. I thought you were doing me a courtesy as a long-term customer. I would never have agreed to this if I had known it was $2,450. Can we rescind this agreement, please, in order to keep me as a customer? And see what they say. A good manager of that business, I think, is going to say, we're talking to the salesman, hey man, make sure you tell him it's not $2,450, it's $2,450. But to that one customer, yeah, we'll make it right. I think that's what would happen. But legally, I don't think they have an obligation to. You'd be having to show probably fraud. You could try to show what's called mutual mistake of fact, but there was a mutual mistake of fact. One person knew it was $2,450, thought it was $2,450. The other person thought it was $2,450. So I think the poster's stuck with this contract, which is really unfortunate. My lawyer didn't show up to my court. Now he refuses to give me a refund. We love questions about lawyer misconduct. Basically, I rushed to hire a lawyer for a case that was not that serious. Since I hired him 6 months ago, I haven't received any information from him. No messages, calls, or any updates with my case. He just made me pay and disappeared completely. It was like that until my court day arrived, and he didn't notify me either. So I decided not to remind him to see if he would show up. The court day arrives, and indeed, my lawyer never showed up. A few days later, I called him to let him know that he'd failed to show up to my court. I told him I couldn't trust him with this type of failure and I no longer required his service, in addition to requesting my money back. A few days go by and I kept arguing with him about my money every day. He finally agrees to pay me, but he told me that he would send a check to my address and I could expect it in 2 weeks. It's been more than a month since that and I still haven't received anything. Apparently he blocked me and my calls, didn't even go through. What can I do here? Any advice would be greatly appreciated. So 2 things are true here. One is, if you're a lawyer and you take on a client, you have to do the job. You can't just bail. That includes showing up to court. Your client's got a court date you have to show up. I'm assuming this is a criminal matter because the fact that it's, you have a court date that you're supposed to show up to. That is not quite how it works in civil matters. Civil matters usually don't get set for a court date, at least in Superior Court where I practice, without the lawyers agreeing on it. The lawyers typically get together and say, all right, we'll do it on this day. Court doesn't tend to unilaterally say, here's when your hearing is, at least not in my state. That tells me it's a criminal matter, which makes this poster kind of stupid because, hey, I'm gonna show up to court and just see if he doesn't show. Why would you do that? You know what I mean? Like, hey, if you think your lawyer's gonna flake, tell him, hey, lawyer, I'm worried you're gonna flake. It's silly to me that you would just like let them make this mistake. So you go, oh, I was right. You did forget about my court. Now I'm going to prison. Anyway, he says it's not that serious. The remedy here is the state bar. The state bar has a fee dispute resolution process that lawyers are obligated to participate in. If a client has a dispute about one of my fees, first of all, I have to hold the money. I can't spend it. I have to hold it. The state bar sort of acts as a mediator to get the dispute resolved. That's the place to go. You call the state bar. You tell them what's going on. You say you want to enter into the fee dispute mediation process. And the state bar would handle it from there. They'll also look pretty askance at the lawyer and figure out what happened here. Why didn't you show up to court? The lawyer could face some disciplinary action. That's the way to handle this. It sounds like the poster is getting the result they wanted. There's an update where it says that they heard from the lawyer and he sent a check and they're expecting the check any day now. That's good. I sort of feel defensive of the lawyer here, and I shouldn't because the lawyer didn't show up to court. But also, I think the lawyer's probably thinking, I'm glad we're done with that client. Did I make a mistake in advising my dad to take the fifth? Without reading anything else, I know the answer to this question is yes, you did make that mistake. My dad, 79, goes hiking in state forests and prefers not wearing clothes. I don't get it. Yep. But I know it's not at all that uncommon. Some people just hate clothes. It is uncommon, actually. About a month ago, he came across a game camera strapped to a tree. Feeling embarrassed, he erased the memory, and then, in a stunning display of poor judgment, he was already walking naked in the woods, so kind of on brand, I think. Took the camera home. When I examined the camera, I thought, you know what? There's a reasonably good chance this is trackable. He should probably put this back or turn it in. Unfortunately, I didn't act on this suspicion. Sure enough, state police showed up yesterday with a search warrant. We turned over the camera and the cops said, okay, so this all started about 8 weeks ago. We got a complaint about a nude party walking to the woods, and you can't be doing that. It's public property. My dad indicated that he understood it wouldn't happen again. The cop then said, and then this camera disappears, and we tracked it to here, and we do have your photo on the camera, so do you want to tell me what this is all about? I popped up and said, you probably shouldn't answer any questions. And the cop said, okay, no problem. You don't have to. So you'll be getting some paperwork in the mail, and they left. My thinking is when the police report that he wouldn't answer questions, they may be more likely that the DA or the state's attorney decides to go ahead and charge him. Whereas this may have been one of the situations where if he'd said, yeah, that was really stupid. I'm really sorry. I was just embarrassed and effed up. A lot of prosecutors would be less interested in pursuing a case against a 79-year-old retiree who's never even had a speeding ticket. So if I'm correct, now he'll need representation that I cost my dad a bunch of money. Answer to that last question is maybe, but maybe not. I don't think a defense lawyer getting involved now is going to do much. The fact that the cop said you'll be getting something in the mail, that's interesting to me. I don't know what that would be. I'm not a criminal lawyer. What I do know is that as a general rule, pleading the fifth, which means refusing to answer questions. You're actually not pleading the fifth, technically, but you're refusing to answer questions that might be incriminating, is sort of a gamble. Here's the gamble. If a cop asks you a question and you answer it honestly, the cop may be more likely to exercise their discretion and not charge you. If you don't answer the question and you tick the cop off, which happens, the cop may think, well, fine, I'm just going to charge you, whatever. My view of it is that not answering questions from the police probably increases your odds of getting charged if the police already know what happened, which in this case, it sounds like they do. But it also increases your odds of being able to contest what happened. If you get charged and you have confessed, you've said, yes, I'm so sorry, that's what happened. I know I screwed up, I shouldn't do it again, I won't do it again. That's damning evidence against you. And your lawyer's gonna be going, there's nothing I can do for you here, you confessed. That's the gamble. And that's why the traditional advice from lawyers is shut up and don't answer questions from the police. That's probably the right advice. The fact that the criminal lawyers all say it means it is good advice. But I do recognize, just from knowing cops, if you do that, you are likely to increase your odds of actually getting charged if they know you've committed a crime. I wouldn't hire a defense lawyer yet. I would wait to see what happens. There's still decent odds that the cop says, I'm not dealing with it. We got the camera back. He's 79. It's fine. On the other hand, walking nude in the state forest is weird and actually could lead to some really, really bad outcomes. I've decided I'm glad that he didn't answer questions from the cops because of how bad it could be. Sheriff arrested my 11-year-old at school. My 11-year-old female child was handcuffed, walked through the school, and taken to the sheriff's department. The classmate told the teacher, blank, name, said she's going to build a bomb. Without any investigation, they shut down the school and arrested my child. They claim they have a video of her saying it, but refuse to show it. The sheriff dropped charges, but the school is still pushing it, but won't share anything with me. I don't know what to do. I'm in Texas. So again, we're acting like we're North Carolina. Commenter asks, the school is still pushing it. What do you mean by that? What exactly are they doing? And the poster responds that she's suspended right now. She has 30 days DAEP. I don't know what that means. Without the investigation even being closed, they're not releasing anything and just saying they're investigating. There's a lot going on here. Sheriff probably shouldn't put an 11-year-old in handcuffs. Just a general rule. Any sheriff's deputies watching this, don't put 11-year-olds in handcuffs. It's never a good look. You can basically always control them without the handcuffs. They're 11. I don't know if there's anything unlawful about that. I don't think there is, but it's a bad idea. Don't do it. The sheriff's office is not pressing charges, so the criminal element here is off the table, but the school is still investigating. I think the school probably has a right to do that. It's been 30 days after a bomb threat. They're refusing to tell the parents anything is concerning, but I don't know if they have to. I just don't know. So this is definitely a situation where if this person was talking to me, I'd be saying, let me give you just a different lawyer. And I'd be going to my network to see who do I know that practices education law. I know that there are a lot of rights in these situations. Like the North Carolina Constitution has a constitutional provision that says that children have a right to education. There are a lot of rights in this situation when you're talking about kicking someone out of school. But this is a really complex one, and it's certainly one where you really need a lawyer. Hospital gave a funeral home my information. Husband was told I was dead. As I'm typing this, I am still very much alive. My husband received a phone call on Wednesday while he was on a job site from a funeral home who he was told, sorry for the loss of your wife. I immediately called the funeral home and they apologized. The hospital had given them the wrong person's information. I tried contacting the hospital and was sent to records who obviously couldn't help me as the funeral home had spoken to a nurse. As I discussed with a friend, some of them encouraged me to contact a lawyer. Are they correct? What type of lawyer should I search out? I'm in Michigan and the hospital funeral home is in Indiana, if that matters. We see this a lot where there'll be what people say, oh, there's a HIPAA violation. I'm going to sue you for violating HIPAA. HIPAA is a federal law that protects your healthcare information, like your healthcare records. There's no private right of action. What that means is HIPAA doesn't say if your healthcare provider violates HIPAA, you can just sue them. Department of Health and Human Services can sue them, but you can't. If you've been injured in some way, if you suffered financial loss, you could probably sue them and you can claim a violation of HIPAA as evidence of their misconduct, but it's not itself gonna allow you to go get any money. That's the first place my mind goes here is like, well, the hospital violated HIPAA by sharing this person's status with the funeral home. But there's nothing there. There's something called a negligent infliction of emotional distress, which is where your negligence, your failure to act reasonably causes someone to experience severe emotional distress. Certainly, someone calling you and saying your wife is dead would cause emotional distress. I don't know if it'd be enough to give rise to that claim. Off the top of my head, without researching, as I mentioned, I believe there's some requirement of some sort of physical injury, either to the person who suffered the emotional distress or to their loved one. So the example would be if someone watches their spouse get seriously injured in a car wreck and they see it, they may have their own claim for the emotional distress they suffer in addition to the spouse's physical injuries. That obviously isn't the case here. I don't know what lawyer I would send them to. I don't know if they would call a lawyer. The top comment says they need to make sure that they haven't been declared legally dead because that could create a whole bunch of issues down the road with the Social Security office. I'm sure that's true, but I don't know what lawyer I would send you to. So I would tell this person I can't help you, but I honestly don't know where I would send them. All right, we'll wrap it up there. These have been some interesting ones. I hope you found this video interesting. If you did, please let me know. Encourage me to keep making them. Thanks.